I'm happy, first of all, because we're in really good company for this second launch. It's our privilege with Antoine to appoint only panel members we enjoy. And I think I can say we have not been doing too bad with diversity. At least I'm sure we haven't had any repeated appointments so far. So far, so good. And as you know, we are here to discuss the diversity at the Court of Arbitration for Sport. And Antoine will tell us more about the topics as a way of introduction in a few minutes. But first, I would like to introduce our two guests today. First, so I'm very pleased to welcome Maître Lisa Lazarus. I can't see you, Lisa, right now, but you must be somewhere. I say maître deliberately.
I am here.
You're here, she's here.
Yes.
Because it's a sort of gender neutral title for an attorney, while there's a debate around whether we should really use what is actually masculine for everyone, but I'm happy with it. And I like the fact that we are all maître. And so also normally I never put emphasis on a competent professional being a woman, since to me she's just a competent professional. But since it's our topic today, I think we can say that Lisa is one of the exceptions that defy the statistics. So she's not a CAS arbitrator, maybe perhaps she will be, but she's one of those women who have really made their way through the world of sport. So she's a US trained attorney. She worked for the National Football League, so one of the major US pro leagues in the US. And then she took a role as a general counsel at the Fédération Équestre Internationale, International Equestrian Federation, which is when I had the privilege of meeting her and working with her. And today she's a partner at Morgan Sports Law, heading their New York office. And so she also acts in particular as a counsel in front of the Court of Arbitration for Sport. And so Lisa and her colleagues at MSL recently conducted a review of CAS arbitrators spanning 20 years, I believe from 2000 to 2020, with more than 2,000 awards, and they analyzed them for gender and ethnicity, which you published online. And more recently, you also published a sequel to that, which discussed the implications of those diversity issues. And of course, that will be of interest for today. And then I'm also thrilled to welcome, I don't know, Johann, whether I should pronounce it the German way or the English way, Johann Lindholm, who is a professor of law in Sweden. And I'm afraid you would have to help me out for the name of your university, Umeå.
It's Umeå.
Umeå.
And it's so like the French O. Umeå.
Okay. Umeå. Thanks, John. So you have worked on topics around European law, comparative law, and the study of the judiciary. But then luckily for us and for today's discussion, you then turned to the study of the sports judiciary. And so in 2019, Johann published a book called The CAS and its Jurisprudence, an empirical inquiry into the lex sportiva. And Johann, so I'm making public apologies today and a commitment, but we haven't been in touch enough. I love what you do. And Johann is an advocate of empirical legal studies. Basically, it means that he sets out to verify what we think we all know, or what we all think we know. And in particular, in part 3 of his book, it's called The Actors. John presents CAS as a network of human actors, and then he performs various types of analyses, including network analysis on these human actors. So I kind of start going into the breadth of the work you did, but you analyzed various hypotheses, repeated appointments, co-appointments, influence on jurisprudence, and obviously you went into diversity matters and why this matters. But I will leave you to tell us more. So let's move over to today's topic. And before we hear from you, Antoine will give us a brief introduction on this theme that is dear to him, since many of you know Antoine is a prolific writer on the CAS and an advocate of improving CAS to maintain its status as a Supreme Court of sport. So Antoine, I'll give you the mic, and then we can move over directly to the you can lead over directly to the first guest.
Thank you, Marjolaine, and it's good to be back. It's good to be back online with so many of you still, so that's good news. And I'm very pleased indeed to have the chance to introduce our topic today and to welcome two super interesting speakers to deal with a topic which I believe is crucial. It's crucial for the future of sports governance. It's crucial for the future of the Court of Arbitration for Sport. There is a real question, I think, whether it should continue to operate like it operates now, and what type of future it should have. And I think the discussion that we will have today is fundamental in this future for the CAS. So what I'm not going to do is to discuss statistics. I'm not going to spoil Johann and Lisa's interventions. They have done a lot of marvelous quantitative work, which also points at things that even if you had the intuitions they were like they are, it's always striking to see the numbers, but that I leave to them. Instead, I wanted to explain a little bit why I believe this is a crucial and important discussion to have, and I'm so happy that we're having it today. I think, like, legal realists have long argued that being a judge is not a mechanical task, that judges, which are traditionally portrayed as, in French we say, the bouche de la loi, the mouth of the law, have a lot of interpretative power, interpretative autonomy, agency in deciding what the law says in a particular case. And that's why I think our societies have developed and put in place quite complex institutional processes to determine who gets to become a judge in a particular court. And obviously those processes are more in public or debated when you go up the chain of courts, and the best known is probably the nomination process of judges of the US Supreme Court, which is not without controversy, as you know. In short, we all know that who judges matters a lot. It matters a lot for the outcome of a final case. It matters a lot for the medium-term, long-term direction of a particular legal order or legal regime. And I believe this is certainly true as well in the sporting context. And if CAS arbitrators are almost exclusively middle-aged to oldish white male from the global north, then it necessarily affects the outcome of the awards. It necessarily affects the content of what some would call lex sportiva or transnational sports law. And this is obviously even more so when you look at issues like conflicts of interest or lack of independence or connections with sports governing bodies. So if the CAS, which I believe is true at this point, is for all intent and purposes the Supreme Court of international or global sports, it matters a lot to try to scrutinize who is sitting as a CAS arbitrator. And that's what we will do today. And it is also really important, and I think this is the second dimension that I hope we will get to in the discussion. It's not only about scrutinizing who gets to be an arbitrator, what is the sociological profile? Is it representative a little bit of the sociology of those that are facing the CAS arbitrators? It's not only about mapping and scrutinizing that, it's also about discussing what are the alternatives. How do you change that? If we get to the conclusion that there is a problem, how do we deal with it? And I think here we are opening a discussion in which I indeed, as pointed out by Marjolaine, have had a bit of involvement in the past, which is about the process of nomination. How do we determine who acts as an arbitrator at the CAS? Do we use a list? Do we open it up? Do we use a closed roster? There are many different options that we can discuss, and I hope we will get to discuss them today because they are as important in a way as the diagnostic that will be provided by our two speakers. And turning now to the diagnostic, I will first hand over the mic to Johann Lindholm for a first presentation of his work, his quantitative approach to the CAS arbitrators. Johann, the floor is yours.
Thank you very much. I hope you can all hear me well. Thank you, Antoine. Thank you, Marjolaine, for putting this together and for inviting me. I of course, agree very much that these are important questions to explore. I have a little presentation that I'm going to be putting on, and I hope that is going to be visible to everyone. It seems like it is. People are nodding along. So I'm in part I'm going to do a shameless plug for the book. Marjolaine already introduced it a little bit. It's now it's already been 2 years since it came out. Time flies, and at some point I want to go back. I want to update and dive deeper into many of these questions. There are just so many questions to explore. But it was at least like a first attempt to kind of make an empirical inquiry into CAS and the L'exportive and how it acts. So first, a quick caveat is that the book deals with the first 30 years of CAS. At some point, you have to stop collecting data and actually start analyzing it. So, but things are moving quite quickly. I think maybe, if I understand correctly, Lisa has maybe some more up-to-date numbers, and maybe she will update us on what has happened since 2014. But largely speaking, I've gone through, and in the book, I worked with all of the full text decisions that I could find, which includes the one published by CAS and a few other ones. And I try to explore basically all these different dimensions. Like Marjolaine said, I tell people I study courts. One of my interest is, largely speaking, judicial institutions, but I also have one leg firmly into sports law, so it felt like a natural fit. But maybe that will inform a little bit because I study not just CAS or even sports dispute resolution. I also study national constitutional courts. I study the Court of Justice of the European Union. I think maybe I'm going to be drawing some parallels between these two. My first slide was, why are we interested in this? I think Antoine had a very good introduction to all of this. I mean, on one level, it's because personal background and experiences shape judicial behavior, as I would call this in a more generalized way. Not to contradict Antoine, because I also write this in the book, the same kind of argument that we know that it shapes, but the causalities are actually rather complex in a sense. There are things we can see where these personal backgrounds experiences do matter. For example, we know that if you have judges that belong to a minority, they will be not just more able to find, or have a tendency to find in favor of other people that belong to that minority and been discriminated, but also more generally. So this is some of the easy things to understand. I think also on a more systemic level, I'm going to talk a lot, I think, about the systemic level, is if personal backgrounds, experiences shape judicial behavior, it is probably also because of how we see the world and what we need to do a good job as judges or arbitrators. So as the world is becoming it's vastly complex, it's very rapidly changing. I think the demand to have people that have various kinds of inputs that come from different perspectives can understand this is necessary to make good decisions on a systemic scale, not just from the perspective of particular minorities. But maybe even more importantly, I would say that diversity is important for institutional legitimacy. And this can certainly go together. Making good decisions, having in some kind of substantive way, having a judicial institution that can make whatever we consider to be the right decisions or substantively correct decisions. The diversity is important by its very self, I would argue, because the institutional legitimacy of the legitimacy of the institutions. And one of these, I think Antoine was talking, or I think he talked about both, but I mean, in one way we can think about this, that it's important that regardless of whether it provides any kind of different kind of results, I think it's important, particularly to the parties, and I'm going to call them here the single shot parties, because I think the equation is maybe a little bit different, that they can see that the institution is representative of them. I think that is important for the institutional legitimacy. By say, when I talk about single shot parties, I'm talking, the most obvious thing is athletes, maybe some clubs, but particularly athletes, individuals that come before CAS, they come before CAS a single time probably in their entire career, and the stakes are very, very high. It's important that they see it as legitimate. And then there's also the other perspective of this, which also Antoine mentioned. If we see CAS as the global Supreme Court for sports, which I think it is, I argue in the book that it is, and in any case, it certainly wants to be perceived in this way. It also means that its cases, its decisions, is not just about the individual parties. It's also on a systemic level. As the court decides a decision, it is not just making a decision for or against the parties that are before it, but it is actually setting a precedent that is going to be applied across the globe. And for somebody like CAS, that is a presides at the top of a global activity such as sports, this really spreads everywhere. So not to repeat, I hope, too much of what Antoine said, but I think this is important for me because I think all of these aspects are important, but they are a little bit different. And I think what we choose to focus on when it comes to reform maybe depends also a little bit on what we want to emphasize. It certainly there's some overlap in this. I mean that some regards of diversity is good and will enhance the CAS in all ways, if you will. But there could also be distinctions depending on what we focus on. So the first thing to take away that is probably pretty obvious, but nevertheless, I think very important, is to understand the distribution of appointments in CAS. So we have the CAS list, like Antoine said, it's a closed list and we can pick people from here. I think ICAS deserves some credit because they are trying to create a more diverse list to include men and women and people from across the globe. They could certainly do better, but I think they also deserve some credit for what they have done. But ultimately, my opinion is that it doesn't matter. You could have a list that was almost infinite. You could open up the list. It's not really going to matter because a small group of people will always be overwhelmingly appointed to serve on these panels. And this is not just true for CAS. Other research shows that you're going to find these kind of patterns in any kind of system where parties get to select their arbitrators. So in my book, I talk about these as super arbitrators, a select group of 16, 17 individuals that get the majority of the appointments. There are some things that can be done to maybe even this out a little bit, and we can talk about that. But fundamentally, this is a pattern we're always going to see, largely because at least that's the dominant thinking, and CAS seems to confirm this. Parties like experience. We like to know that we are picking someone who is experienced in settling these kind of disputes. There's also maybe a certain element of just knowing what we get, that we get people that are not going to be too outside of the norm. There's a level of certainty or predictability in picking people that have been there before, and there's probably an argument to be made that with experience comes a certain number of influence. This is also why, if we have two super arbitrators on a panel, I would venture that it doesn't matter much who the third one is, because that person is simply not going to have that much sway over the discussion. That's speculative on my part, but this is certainly true for many other institutions, that you get listened to more if you have more experience. This is not, so I wouldn't say this is like a big conspiracy or something like this, but this is a part of the problem, and I think we have to attack this head on. So many of these super arbitrators that I identified, and I think this is largely still true, are going to be, many of them are Swiss, German, a few other Italians, French. There is large group of people that come from a very limited group, an area, a geographic area. They're all men, and they're all white. This was just an illustration to say the same people are basically, this seems, every dot here is an arbitrator, and this is who they are appointed by. And not to go too deep into this, but basically there isn't so much of a difference between the individual athletes that come before CAS and the sport governing bodies, or for that matter, the clubs necessarily, in who they appoint. Everybody likes basically the same people, at least if they have experienced counsel and know who the main arbitrators are. They seem to appoint the same kind of people. But that being said, so there's a general expression. There's that arbitrators in the world of arbitration are pale, male, and stale. This is at least as true for CAS as every other arbitration body, arguably even more so than some arbitration bodies, but maybe not a significant difference. So this picture shows where the appointments are coming from. So instead of looking at the list, we look at where, like, each appointment is one appointment, and then we just plot these geographically across the world. And for many arbitration institutions, we would probably expect to see a little bit more, for example, North American ones. CAS is definitely Western. It is a lot of North America, Australia, and Europe, but particularly on the European scale, it is heavily, a lot is in Europe, and particularly in Switzerland. There are some natural reasons maybe for this. CAS itself is there. The big sport arbitration, sport governing bodies are there. And so the general geographic proximity to CAS can certainly explain much of this, but it's nevertheless a problem. So this is the map of the arbitrators. And if we look, and we instead look at who the parties are, we can see that, yes, I mean, to some extent, this is true, that many of the parties are also from Europe, but it's not exactly true. This is looking at the latter half. So the last 15 years that I studied, because it has been spreading more generally. And we do see today more South American parties, we see more Asian parties, even African parties, even though many African countries haven't sent, at least in my data, to CAS. It is becoming much more globalized, but CAS itself is not necessarily becoming more globalized in terms of who the appointing arbitrators are. A very quick point, and I read Lisa's excellent articles, so I think she might talk more about the gender dimension on CAS and the appointments. It's, at least for this period that I studied it was terrible. It wasn't looking like it was getting any better. It is particularly bad even compared to many others. So on average, over the studied period, the women female arbitrators get 3.6% of the appointments, which is, of course, abysmally low. I wish, the reason I put these dots here is because you can then see how these are distributed by year. And at least when I was looking at it, it didn't look like it was getting any better necessarily, but I'll be interesting to hear if there's been any update on that. They're also old or oldish on the upper part of the scale. So at the time of appointment, when they make their decision, they're going to be around 54, 55 years old. I guess today that is maybe not super old, but it is certainly much older than the athletes that come before them. Very few athletes have the luck of being active that long. And this is, of course, also a problem, like I said, for example, from the perspective of seeing sport as a rather fast-moving business sector. Having people who have maybe both in terms of representative, but also in terms of knowledge I think is an issue. At the same time, we also want, of course, experienced arbitrators. So there's some level of trade-off on these issues. So just very quickly, because I wanted to a little bit hit on the question that Antoine also raised. How do we then do something about this? Well, first of all, I would say this is a general problem in arbitration. It's not necessarily specifically a CAS problem in some regards, because parties value individual case outcomes. They want to win, makes sense. At least the single shot parties are going to be focused on their individual dispute, and they value arbitrator experience in terms of getting the kind of outcomes that they want. However, that being said, I would emphasize, there are different ways to approach this. I tend to emphasize this institutional legitimacy that we were starting to talk about. So it creates a paradoxical picture to some regard. If we're saying that everyone keeps picking the same pale male stale arbitrators, including the athletes, and then we're saying at the same time that athletes deserve to have a body of arbitrators that are representative of them. It might sound like a contradiction, but I think the way to think about this is to distinguish this and to recognize that CAS, although it is set up as an arbitral body, has some characteristics, exercises some functions that are more similar to, for example, a national Supreme Court. And we wouldn't say that if we take the systemic kind of view to a judicial institution and we talk about enhancing its legitimacy, I think there are we would think about this differently. And I think we would maybe consider doing it differently than we traditionally have done when it comes to arbitration, because I think we're stuck in a sense in the framework of traditional arbitration, but CAS is not that. Obviously, ICAS and CAS needs to take responsibility for institutional legitimacy. I think this goes without saying. I think there are some things that can be done, for example, in terms of using the appointment powers of the president of the panels and the sole arbitrators. This is an easy way for CAS to boost certain arbitrators' experience and then probably parties' willingness to appoint those people. But I think also, in all fairness, I think the sport governing bodies, and particularly what I would call the repeat player sport governing bodies, have a particular kind of responsibility for this. They are, of course, exercising an influence. They're kind of in between, because they exercise influence over ICAS and then by extension CAS. But they are also the ones that are using this on a repeat basis.
Oh, I think Johann froze because we are still on, aren't we?
Yes.
Yes.
So this is not the first time this happens. What shall we do? Shall we maybe, well, let's wait to see whether Johann comes back, or otherwise maybe we'll give the word to Lisa first and then have him finished when he's back.
Yeah, I think that would be better at this point.
Yes. So Lisa, maybe do you have anything to share too? So
I do not. I am going to present the research orally, and so we'll not have a fancy PowerPoint like Johann. But I just hope to speak directly to everyone. So would you like me to begin, Marjolaine? Yes?
Please do. Yes.
Okay, great.
Thank you.
So
Sorry
first
for
of all,
the transition.
No problem.
The lack thereof.
It's no problem. In this Zoom world, we all have to kind of go with the flow. So thank you very much for inviting me to be a part of today's conversation. I think it's incredibly important, very timely, and very thought-provoking, and it's a privilege to hear everyone's research. I am also privileged to present our research today on behalf of Morgan Sports Law, and I'm very indebted to all of the people there who worked hard with the original research with the numbers, led by Mike Morgan. And as a consequence, I am delighted to be able to kind of share that information with you. I see Johann is back on. Johann, we were going to go ahead with my presentation right now, but if you're unfrozen and you want to finish yours, please go ahead. No, okay, he's still frozen. I'm going to make use of everyone's time then. So just to give a background on essentially sort of what the methodology was for the research, I'm going to start with that, and then tell you what our findings were, and then of course talk about some of the suggestions or items for discussion, many of which we're also covered to some extent by Johann, but I think we sort of look at it also from a different perspective. At Morgan Sports Law, we are lucky to be often before the CAS, and so this is an issue I think that many of us have been talking about and wondering about and identifying for some time now. So with regards to the research itself, we reviewed all CAS awards between the years 2000 to September. Well, really, we started in January of 2000 and went all the way through September of 2020. So essentially, 20 years of CAS awards. And we did that by accessing the CAS jurisprudence database. And we essentially had 2,081 awards, and we counted consolidated awards as multiple awards. So we ended up with sort of this body of work of 2,081 awards. And the kind of key data we extracted from that sample was we looked at the date of the award, the parties' identities, also the party types. We looked at, was it a sports institution, athlete, club, non-athlete individual, et cetera. We also looked, because it's relevant, and whether the case was heard by a 3-person panel or a sole arbitrator. We looked, of course, at the identity of the arbitrators appointed, and then who appointed each arbitrator. So was it CAS, a party, et cetera. We looked at the gender and ethnicity by reference to skin color of each arbitrator that had been identified. We relied on the CAS arbitrator list where possible for gender. We also used other sources if we felt like we had to clarify, like law firm websites, professional profiles. And then using Excel, we took all the statistics out regarding arbitrator appointments overall and by the CAS. And we also looked at the 5 most frequently appearing sports institutions. And then these statistics were what formed, our first article, which many of you, I believe, have already seen. But I'll include some of the kind of headline figures from that first article in my presentation, and we'll also look at, obviously, the outcome of the second, more recent article. So we also looked very carefully at the current CAS arbitrator list and researched the gender and ethnicity of the listed arbitrators. And this is sort of an overlapping but different group to the above, because it includes individuals who are not appointed in the cases we studied in that 2,081 figure identified, but does not include individuals who were appointed in the cases we studied but have since retired. So it's a slightly different sample, but of course, primarily overlapping. And so what do our conclusions show? So of the, in that body of cases, we found that there were 330 arbitrators who were unique arbitrators appointed at least one time. So this is the group. There were 330 over that 20-year period that were appointed at least once. And of that, when we looked at that number and we broke it down, we found that 235 of that 330 were white males. We had 38 that were female, 57 that were non-white. And then within the non-white group, we also looked at the Black arbitrators, and there was only 12 of the 57. So from a statistical standpoint, what that means is we had 11.5% female appointments on that unique list, 17.3% of non-white, but then only 3.6% of Black, which was, again, the non-white includes the Black arbitrator list, but then we also looked at that sample separately. And then we looked at the overall appointments, like the gross number. And so if you look at 5,053 total appointments over that period, we had the female number was 226 female appointments, 401 non-white, and of that sort of 401, there were 42 that were identified as Black within that 401 number. And now that really dropped the statistics meaningfully from the unique arbitrator list, because obviously you have this, this goes back to the super arbitrator concept that Johann identified, which, you have multiple appointments of some of the very same white males. And so those numbers were really, quite grim, if I'm candid. It was 4.5% were female, 7.9% were non-white, and then there was only 0.8% that were identified as Black in that, out of that 5,053 number. So the question was also posed by Johann, like, how do things look from a sort of a time standpoint? And we did see that these gender and ethnicity characteristics or appointments did get better over time. So if we look, kind of in the most recent years, we do see some improvement, but in our view, not good enough and not significant enough to really get us to where, of course, we'd like to be. And we compared these, like the gender diversity statistics, to other international arbitral tribunals, like the ICC and the ICSID. And, it showed that numerically CAS was behind those other institutions with respect to gender diversity. We also looked at the diversity of the appointments made by CAS itself, because obviously CAS has a very meaningful role in making appointments. It makes probably the most appointments of any of the entities. Presidents, sole arbitrators, ad hoc arbitrators. And we found that the CAS appointments were similar and basically tracked the same statistical outcomes that we saw for the sort of global appointments. And specifically, the appointments by CAS were 4.8% female, 6.2% non-white, and then within the non-white category, it was 1% of Black arbitrators. Now, one of the things we also thought was interesting to look at, and we sort of extracted and evaluated separately, was the appointments made by the 5 most frequently appearing sports institutions, which were FIFA, WADA, the IOC, the UCI, and UEFA. And we found that their numbers were actually slightly poorer and worse than the overall numbers. So between them, those 5 institutions, they had 517 appointments with only 17 to females, so 3.3%, 31 to non-white arbitrators, that's 6%, and there was only 1 Black arbitrator appointed, which accounted for 0.2%. Now, also, we also thought was interesting because, with CAS, you of course have these repeat appointments, and that also is valid to some extent for the female arbitrators that are appointed, because of the 17 appointments of female arbitrators, it included only 4 unique women. So it was 4 women who were appointed for a total of 17 times. And we thought was somewhat, concerning or disappointing is that in 184 appointments, the IOC, UCI, and UEFA combined appointed only 1 woman, and that was by UEFA during that entire period. And in the 131 appointments in total, the IOC and UCI did not appoint a non-white arbitrator. Now, the current cast list, because this may also say to you, okay, well, who are they choosing from? What does the list look like? And I think we kind of all have a fairly good sense of what the list looks like. But the cast arbitrator list is more diverse than the appointments we studied. It is 12.5% female, 24.5% non-white, and 4.4% Black. So it is not in itself restraining appointments. There is that universe of diversity on the cast list that would allow for more diverse appointments if the appointments were made that way. So I think ultimately, and I'll talk about this a little bit more, like, we think to the extent that improvement can be made, and obviously we would like to see that happen, it really is around the appointment process. So Johann touched on this, and I'll also share much of his conclusions and suggestions, but just giving it a bit of a twist on related to our research. Why does diversity matter? And our main points here are, and I think actually Antoine said that who judges matters a lot, and we would concur with that. Arbitrators hearing disputes should be as diverse as the parties to ensure legitimacy and a greater understanding of relevant personal circumstances and life experiences. Being an American lawyer and coming up through sort of the US judicial system, you always hear about the importance of a jury of your peers. Doesn't mean your peers are going to agree with you or find in your favor, but they have a lens that's different, and that lens is important. We can't everything, I think as individuals, it's impossible to extract the personal from the professional. You always have some of yourself in whatever you do. And that holds true here as well. We also looked at some research, and the research that we looked at suggests that diverse groups perform better than non-diverse ones. For example, there was a mock jury study that showed that diverse groups considered issues in more depth and with fewer mistakes. And also, arbitrary diversity will help to reduce the perception of caste as lacking independence and being weighted against athletes. And I think, on this question, it's really interesting, the point that Johann made and asked us all to consider, which is there some sort of inherent conflict here? Because the athletes are basically appointing the same way that the sports institutions are, or CAS is. And I do think, we have to look at that from various angles and consider it. And I think, coming from a firm that represents almost exclusively athletes, I think you are in a bit of a conundrum, because when you talk about the super arbitrators, if you do have two appointed to a panel and you're looking to appoint the third, you have to consider how much influence somebody new or somebody not tested, doesn't have the credibility, how they're going to fare on a panel with two super arbitrators. And we have to obviously advocate for our clients the best of our ability. And at the end of the day, that means giving our clients the best chance of success. I'm certainly not saying we can't do that with diverse arbitrator appointments, and that's something I think is very important to our firm, and that we don't take lightly. But there is that sort of super arbitrator panel issue that I think is one that lends itself to more discussion, more consideration. So how can the diversity problem at CAS be resolved? That's, I think, to some extent, the subject of our discussions today, but I'm going to offer maybe a few different proposals or ideas for consideration. So from our research, it seemed that the main problem is the appointments process. Our research showed that on average, each female or ethnic minority arbitrator receives fewer appointments than each male and or white arbitrator, and the appointments are less diverse, as I said, in the current CAS arbitrator list. So to tackle the problem, our main proposals are: one, stakeholders can ensure their recommendations of individuals to add to the arbitrator list are diverse, and they can take it upon themselves to appoint those arbitrators. I think, that, as I said, that seemed to start to happen a little bit more towards the end of our research. And that's obviously something that I think is necessary to move the ball forward. But again, I think that in and of itself may not be enough. CAS could impose a limit on repeat nominations by parties. That could potentially be something that addresses a super arbitrator problem. And listen, many of these super arbitrators, we appoint and are excellent. So no one's criticizing them per se. It's just how do we change the dynamics? How do we make it more diverse? Sports arbitrators, institutions, could commit to arbitrator nomination policies to improve diversity. This is particularly important given that the main sports institutions we refer to are responsible for so many of the appointments, and they've also, many of them have made commitments to diversity and inclusion. And again, sort of, I think it was mentioned earlier that I spent a fair amount of time at the NFL. And actually, when I was at the NFL, my job when I first started there was to represent the teams and arbitrations, actually against the athletes on sort of management side. And it was a very different formulation because the American leagues are unionized. And so that list is jointly appointed by the union and management. And it's a closed list and it's a permanent list. And actually, I found while that system, again, is not apples to apples with CAS or the judicial system in Europe, because you don't have the unions playing the same role, you don't have the collective bargaining agreements or the that sort of equal bargaining power. But having that list did increase diversity for sure, even many years ago. And it also avoided the sort of super arbitrator issue, which is that everyone was kind of working off the same list and it was almost like a rotation. So that's, I think, something that is worth kind of thinking about and maybe potentially thinking about how we can borrow some lessons from that process. Because I do like, I think Antoine suggested before, this idea of a closed list or sort of a vetted list. And I think that's a really interesting proposition. And also CAS could, of course, commit to an arbitrator nomination policy that improves diversity. This would likely be impactful because CAS is responsible for 45% of the arbitrator appointments. And we looked at a system that's similar to this that already exists, the National Sports Tribunal in Australia. And I think it's been quite successful at achieving greater diversity. Wing member arbitrators could consider diversity when appointing a panel president in ordinary cases. That also, I think, would really move the ball forward, because we certainly see also in panel presidents that you see obviously a lot of the same appointments. And again, you have to consider experience, and experience is important, but I think this could potentially be a way to also open the door a little bit more. And then use of the closed arbitrator list is also, so I'm contradicting myself a little bit here, but I'm offering different ideas. Could be scrapped and you could make it sort of more open. But again, this is something that's been suggested before, but I think it doesn't get to, it may not be able to address this bigger problem of appointments, which ultimately, we believe is at the heart of the issues here. Now, I'm going to make sort of two final more points before I turn it back over. Separately from the very direct, I think, proposals that I've mentioned or that we've discussed, I think there's also potentially a role to be played by CAS, stakeholders, sports institutions, just in terms of being more active in helping to develop women and ethnic minorities to put themselves in the position where they can actually where they are to be able to be nominated and also to do a really good job. I mentioned that the list itself is not a problem, but certainly more heavily populating the list with successful, competent women and minorities would certainly, I think, further alleviate the problem. And that does require, a system that encourages diversity in development, in roles that ultimately make you competent and eligible to be appointed as a CAS arbitrator. And so that pipeline, I think, also can be, it's more of a sort of a soft point, but I do think that helping to develop that pipeline is important. So I'm just going to conclude by saying, ultimately, CAS and the sports governing bodies could solve a lot of this issue by the volume, because of the volume of appointments they make, and by being more diversity focused with regards to appointments. And at that, we believe would have the biggest impact, immediate impact. but there's also obviously a lot to be talked about in terms of how to look at the issue far into the future. So thank you for the opportunity to present the research, and thank you to all my Morgan Sports Law colleagues for doing most of the hard work. And I pass it back to you.
So thank you very much, Lisa, and thank you also for already putting all those proposals into the room for the discussion. Maybe we'll give the opportunity to Johann to add finish his presentation / add some reactions to Lisa's presentation now. And maybe for those participants who already have a question in mind and would like to intervene on the mic, maybe you can drop your name and the topic of the question into the chat already now, so we can already look at some selection for afterwards. So Johann, back to you.
Yes, thank you. Apologies for my poor. I don't have apparently a good internet connection, but I hope you can hear me. I didn't have so much left. I'm very sorry that I missed also the beginning of Lisa's presentation. I was really looking forward to hearing that, but at least I caught the end. There was really sort of only one major point I did like many of her recommendations. I think they're wise. I would like to add one thing. In this spring, I wrote an editorial for the International Sports Law Journal, which I think attaches a little bit to this. I think if we think about CAS and really take it seriously as a kind of global Supreme Court for sports, I think we should assign the judges according to what we know is best practice for those kind of bodies. I don't think we would tinker too much. I think we would open our minds to more radical solutions. We don't let people pick their judges in national courts, and I don't think necessarily we should let parties pick their arbitrators in CAS. I realize this is probably this is going to be a long step before realistically everyone is on board with something like that. But I think that's the direction in which I think we need to be heading. The problem is not, and Lisa said this too, the problem is not that we have super arbitrators, that a few people are getting most of the appointments. Not only is this probably inevitable, but we really want this. We want a few people. If you're going to have consistency, if you're going to have good outcomes, you want experienced people who do this day out and day in. So I would advocate for a more permanent body of judges that are assigned to cases by rotation randomly. Don't let people choose. Basically, if we're going to have super arbitrators, which I think we should have, then we have this opportunity both to create a diverse body of judges, but it would also help with some of the other problems of CAS when it comes to the independency of the arbitrators from the big sport governing bodies, from CAS itself. And so that's all. I think we could go in that direction. The EU is pushing a model for investment state dispute settlement that they call the investment court system, which basically is that it's taking the best practice from the realm of state-based courts and international courts and putting that into the arbitration world. And I think that might be a good idea, and I think it would enhance diversity. Thank you.
Yeah, Majlan, if I may jump in just on that, because obviously this has been one of my cheval de bataille for a while now, and I think it's one of the questions that is crucial in this discussion is, do we continue to look at arbitration as a model, or do we turn to international courts and national courts as an alternative model for the structure of the CAS? I've been obviously advocating for the latter since almost 5 years, but I think the debate that we're having about diversity, still then we would have to have it, even if we take the second model as our starting point, because if we take the super arbitrators, as pointed out by Johann, that we have right now, and give them tenure, we would have a really nice group of very old white European male. So here we still have to reflect on how are these super arbitrator or permanent judges nominated, by whom, and here coming back to, I think, one point of Lisa, I think there is a huge responsibility at the level of the CAS administration in the group of super arbitrators, in defining the group of super arbitrators that we have right now. As pointed out by Johann, the CAS exists for over 30 years. The people that are super arbitrators right now, 20 years ago, they had no experience. That experience was built through nominations, and in particular through key nominations as president in important disputes and awards that are talked about for years to come. So, and in that regard, the CAS arbitration has a crucial responsibility in the current setup in defining who gets to be seen as experienced after a certain amount of years. And I will stop there. And I think we should take questions. Another option might be that people raise their hands and then we can also give a word. But I see already one question, which I think is really relevant as well from Gerald. Gerald, do you want to raise the question orally, or should we raise it? I think okay, I'm happy to do it. Because I think it's a really good question. It's about training. How do you become a sports lawyer? And indeed, the point is, currently, the cost of doing a sports law master can be very high. And this is, as such, an impediment to becoming a recognized sports lawyer and maybe a CAS arbitrator. And this is something that I think Lisa touched upon a little bit, and I want to give her the floor on this, and as well to Johann as an academic. What is the responsibility in terms of education? So turning to education and how to facilitate access of women and of, for example, arbitrators from the global south to knowledge.
Yeah, I mean, thank you for the floor on this. It does relate a little bit to my pipeline comment, which is that it's really important to have mentoring programs, to have stakeholders, take real affirmative steps to help create a body. I don't think you necessarily have to go and get a master's and pay for a master's to, I'm sure, the majority of the CAS arbitrators did not do that in order to qualify yourself. One of the things in the US that they've had in place, some of the major sports leagues for a while, are essentially obligations on behalf of teams for head coaching and management positions to interview. They have to interview a diverse group. And I think it's about, and then they can select whomever they want from that group, but they have an obligation certainly under NFL league rules. It's called the Rooney Rule, to interview women, to interview people of color, and then they can make a decision. I think the learning behind that is, if you actually get the people in the door, if they get in front of you, if they have a chance to present themselves, that may very well impact your decision and impact your appointments. I've been very fortunate in my career to be mentored by some fantastic people at the NFL, at the FEI, now by Mike at Morgan Sports Law, and they've all been white men, and they've all, been motivated to help me, and I'm very grateful for that. So I think there is an affirmative duty, I think, in our sports world to help give diverse candidates real opportunities.
Johann, you want to add something?
I mean, I made it. On one hand, I want to say that I don't know much about this because I'm just an academic. But of course, when we're talking about academic training, there's certainly an element of this. In Sweden, all education is free. So that's one suggestion, to come and take. do your training in Sweden if you can. No, but generally speaking, I think this is also it is something worth considering what we can do, like when we design our programs, if we have influence over admissions and so on, that we create programs that are accessible. One thing that maybe has come out of the pandemic that is a good thing is that it has been a lot by putting things online, including even things like this. I mean, this is an example of an open fora that is available to anyone with an internet connection that is without cost. And I think we're seeing more and more of this. It becomes a way of being educated. But then again, I think Lisa is absolutely correct. It's one thing to be sort of educated and have the knowledge, which is of course important, but I don't think that's an obvious sort of how that translate. Maybe we do need a broad base, a diverse base of sports lawyers, absolutely. But to take that step from having people that are sport lawyers to become participating, and then all the way to getting these people into appointments is a very, very long step. It's going to take a long time.
Maybe I would like to add something on this, because in Switzerland we are actually privileged in the sense that we actually have specialized masters that are incorporated into the actual university program. So you can have a specialized sports masters in sports law as part of your usual studies, which are not the US fees, obviously. For you have to pay something for your studies. But in general, I think I agree with what Lisa said. And when I saw the question, I was realizing actually how old I am now, because I was thinking, well, when I started into this, it was relying on being mentored, on being interested in the subject, and on starting to work on it. I don't think that when I started doing CAS arbitration, there was any sports law program, or at least it wasn't usual at all for people to have gone through these programs. And now it seems to have become almost habitual for people to have to go to one of those programs to be part of that sports law world. And I think that shouldn't necessarily be necessary. And as Lisa said, it's not necessarily sufficient either. So that's what I can contribute. And I think we are other questions coming in. So we have questions still about the programs, but I'd like to take the other question. Sorry, it's moving too fast. Maybe Antoine, you have a question that you have understood and want to take.
I can pick up because I've read a bit the questions. So I think there's one question which is really about the current application process to become a CAS arbitrator. And I think, both Johann and Lisa will have something to say about it. And in a way, this connects again but there are two levels to that. There is one, is it really difficult to become a CAS arbitrator? And second, but is it really difficult to actually become nominated as a CAS arbitrator in a CAS arbitration? Because getting on the list doesn't get you very far if you're not nominated. So there is two dimensions. First of all, how do you get on the list and how difficult is that? And the second is, I think, well, but once you're on the list, how do you get nominated? And again, I would turn first to Lisa and then to Johann for that set of questions.
So I have to confess, I haven't looked at what exactly you need to do to become a CAS arbitrator in a little while, but the last time I did look at it, it did not seem very difficult. If you're a practicing lawyer and you have a legal education, my perception and my experience is that it's very difficult, though, to become someone who's regularly appointed. And so it's almost as strange, the way that I've, experienced it on a personal level. It's sort of the strange thing of you get on the list and then your campaign starts for actually being used for being nominated. And I think that also, you know, can put arbitrators in a bit of a dilemma. I'm not suggesting that anybody doesn't have integrity or isn't fair, but you know, you have to think a little bit about strategically, how do you get yourself appointed? And maybe that means consistently ruling for one type of party, consistently ruling a specific way. And I think, and again, if I contrast that to my experience at the NFL, where there was a panel, a permanent panel that was jointly appointed by the players union and the league and the sort of would be the governing body in Europe. That was a panel that they agreed on jointly. It was diverse, and then there was a rotation, and nobody on that panel had to kind of market themselves for appointment. And so I think that is, you know, an interesting formulation, which is getting on isn't so hard, but getting actually utilized is quite hard. And we saw that in the numbers of arbitrators that exist in the list versus who's appointed and how regularly. Pass to Johann.
Yeah, I think I haven't tried to get on the cast list, so I'm not exactly sure how hard it is either. I get the feeling that it isn't a bad idea to maybe know some of the people to get recommended, maybe have somebody to guide you to get on there. But if you are reasonably qualified, I think it can work quite relatively easy. I think, at least my impression is that ICAS wants to have a more diverse list. I think if you are not a middle-aged white Swiss man, I think it's going to be a lot easier probably even to get on this list, but does it really matter? I mean, I think there's also two other things a little bit attached to this, that where you work, I think if we were to go behind the pure numbers and the individual names, and we see like what are the law firms where these people work that are super arbitrators, the repeat ones, many of them I think are working for law firms that work generally in arbitration. This is also true for some individuals, that the people that are super arbitrators in one system are also going to be super arbitrators in other arbitration systems, in a sense, right? So it's not even, I guess from the individual's perspective, if you want to become an arbitrator, it's nice because once you build reputation as an arbitration in one system, you can transfer over to another one. But it probably also means that the threshold is really high. So I mean, in that regard, one question of increasing another actor that I didn't have on my slide, but that arguably could play a role in increasing diversity, are these big law firms specialized in arbitration. They certainly have an influence over this.
Yeah, I mean, Marjolaine, I don't know if you want to add to that discussion or to.
Yeah, I just wanted to say one word about what Lisa said. So the leap between being on the list and then actually being appointed, and this is all the more important because once you're on the list, you can no longer be a counsel before the CAS. So you have to take that leap of faith that you will then get appointments, because if you are an attorney, of course, if you are a university professor, an academic or something else, then you don't have that issue. But for all sorts of good reasons, for a number of years now, CAS arbitrators can no longer represent parties in front of CAS, and the new exclusion is now also for submitting expert opinions in CAS proceedings. So if you're a CAS arbitrator, I think since this year, 1st of January of this year, you can no longer submit expert opinions, legal opinions in CAS proceedings. So being on the list has important consequences. Obviously, if you are not, if you do not receive appointment afterwards, and if you have no other significant professional activities beside this type of work.
Yes, I don't think it's totally easy either to get on the list. I think we should be clear that they are using certain requirements in terms of qualification, which I think would filter a certain number of application out. One of the problem is that it's very unclear why people are getting on the list and why people are not getting on the list. So this is all done at the ICAS level in a context of total opacity. So the criteria are, again, the application of the criteria is not really clear to any observer. So we don't really know fundamentally why someone gets on the list or someone doesn't get on the list. This is one of those black box decisions that come out of the ICAS, and which I think is also one of the institutional problem of the CAS. We have many new questions. Marjolaine, did you have a look already at some of them?
Yes, well, there are many questions again around the education. There is maybe one other aspect to have the time to address other topics, and then we have a hand raised. Maybe afterwards we can take Jorge, who has raised his hand. But there is a question about, in the end, which is about why it matters. Alberto Cario says, well, it's there are two different issues. One is increasing diversity, but then actually, what is going to be almost the KPI for that? Is there an issue about ethics and integrity of the arbitrators, and would it be, in a way, is there a suspicion of partiality among arbitrators right now? So what would it change? So maybe we'll have our two speakers react to that, and then we'll take a question.
So
okay.
I think that's, oh, Johann, did you want to go first?
No, please go ahead. Go ahead.
Okay. So I think that's it's a really interesting question. It's an important one. And I think this is the nuance a little bit that people have to kind of get their heads around, which is no one's asking, I don't think any of us up here are asking or suggesting that we want some sort of certainty around outcomes, or if you have if you have a female athlete and a female CAS arbitrator, that's going to mean the female athlete has a better chance of prevailing. That's not it at all. It's a question of, like, when you sit as a stakeholder, as a party to a CAS arbitration, and you are a member of an ethnic minority, or you're a woman, whatever, and you look at sort of an older all-white male panel, how does that make you feel about the process itself? And what are the perceptions, and what are the perceptions about balance? I mean, I think we're seeing initiatives, across every business and world about trying to make decision makers, communities, whatever the community of decision makers, more diverse for the people that are impacted. And so it's not about certainty of outcome. And I think, all of us here are lawyers and value sort of the sanctity of impartiality and the importance of a fair and complete process. And I think it also undermines, I think, the value or the integrity of the female or non-white arbitrators to suggest that they would simply rule a certain way because of the identity of the stakeholders. But it's about the perception of a fair system. And I think that's what it's about, giving opportunities to communities that have been typically disadvantaged or not been in the prevailing majority. So I think it's important to basically separate those two issues and understand that they're very different. And no one is suggesting that a more diverse cast member is going to rule a certain way. That's my perspective.
I think, Lisa, Alberto's point was a bit different. He was saying, well, if we have a more diverse cast, but it is still structurally captured by sports governing bodies, even the more diverse set of arbitrators will be, in a way, still captured by sports governing bodies. So, okay, so I think that was the point of the question.
Yeah, so I understood it a bit differently. And let me just give a really quick answer to that, because that's a very important one. Because at the end of the day, the panel, it matters also very much, like who's responsible for appointing, if we have a sort of permanent set panel or permanent arbitrator panel. Obviously, the role of the ICAS and the fact that it's majority governing bodies has an impact. And so, yes, that is a point for consideration. I think that having a closed list would require that, I think, multiple stakeholder groups have a voice in who's on that closed list. That's all.
Yeah, I can just echo. I mean, I think it's difficult to talk. There's certainly this question, sort of ethics and integrity, partiality, some of the perceived problems in this regard. I'm a little bit hesitant to kind of say that it's obvious that it has an impact. That in sense, like even though Antoine said like they are captured by the sport governing bodies. I guess I can see what he's saying in some regards, but do we think that they are necessarily on a systemic level favoring the sport governing bodies? If so, why? I think that's a hard question. I see this part, that part, if we want to say, if there is a view, at least that there is a problem with partiality, that's a problem in itself for the legitimacy of the institutions. That's how I would connect these two kind of strands. That these are two issues that both undermine the legitimacy and the perception of the court, whether or not there are different outcomes, whether or not these are representative, whether they can have an inclusive perspective of minority groups or not. In fact, there's a problem with legitimacy if it is perceived in this way. But they are also, like Alberto pointed out, somewhat different issues, but I think that's how they connect.
I was reformulating the question, not stating that the class is captured. But even though you know very well that I do think that there is an issue with independence at the CAS and that is structural, institutional, and might be difficult to evidence on a case-by-case basis, but indeed poses a question of legitimacy in general in the eyes of the justiciable, which is important, as you pointed out. Let's turn to Jorge, no, for a question live for the first time.
Good afternoon. Do you hear me? Okay. Good afternoon to everyone. Thank you very much for the lecturers and the organizers for this webinar. It's been very interesting. More than a question, I have a couple of comments with regard to how to become an arbitrator. I'm not an arbitrator, but what I can see is that the criteria for becoming, I used to be a counsel for the CAS, so I know it a little bit, even if it was a long time ago now. But basically, there are three or four requirements that you have to meet. One is that you need to be a lawyer, whether a professor of law, a judge, or a practicing lawyer. That's the first condition. There are no, to my knowledge at least, there is no arbitrator who hasn't qualified as a lawyer. Second, you must have some knowledge of, second, you need to speak the languages of the CAS, which are now three: French, English, and Spanish, as everyone knows probably. And the third one is that you have some kind of experience, either in arbitration, commercial arbitration, or any kind of arbitration, or in sports in general. So you are required, I mean, you cannot expect, to my knowledge again, to become a CAS arbitrator if you do not have some experience and some quite advanced knowledge in either in sports or in arbitration. These are the criteria which are applied. Then there are additional criteria, as Marjolaine mentioned, which are that you must not act as a counsel once you are nominated, but there is an additional unwritten requirement, which is that, and this is quite recent information, that applicants to become arbitrators who are in a law firm which is actively practicing sport law in front of the CAS have very little chances, if any at all, to become an arbitrator. So in other terms, there is an additional filter, which is the CAS does not want to have an arbitrator who is a partner of a law firm which is representing parties in front of the CAS on a regular basis. And the other thing is that there is some kind of diversity in terms of countries. The CAS likes to have not too many arbitrators coming from one country or another. There are too many Swiss arbitrators, so contrary to what you seem to say, Antoine, it's not easy to become a CAS arbitrator if you're from Switzerland. Because there are many arbitrators coming from here. It's easier to become a CAS arbitrator coming from other countries which are less represented. And probably also easier, and I'm sorry if I shock anyone, but probably easier also to become an arbitrator if you're a woman, because there are fewer women than men on the list. So this is a message to all the women who are listening. Take your chance if you meet all the other criteria. Take your chance, because you have a good chance to become a CAS arbitrator, being a woman, probably more than if you're a man. There are some new CAS arbitrators who are females who have been appointed in the last years, and some of them, like Karine Duperron, for instance, to quote one of them, has been appointed quite quickly, both as sole arbitrator and as chairwoman or president of the panel. And so it's not only just an excuse to have women on the CAS list. It's actually a chance once you're on the list that if you meet all the criteria, and if the CAS have some confidence, they will even give you the chance to sit as a sole arbitrator in one case, to see whether you can handle it properly, and thereafter, like for any other man, to have other chances to become the president of panels thereafter. I agree with you, Antoine. It's the procedure is quite obscure, and it's an institution which works as it does, and it's quite successful. We have to all to admit. But we have to keep in mind something which is crucial for arbitration. This is private justice. It's not public justice. It's private justice, which is supported by international federations and the sports movement in general. That's true. But it keeps on being private justice. The CAS is a foundation, a Swiss foundation, private. And so they like it or not, they will disclose the information that they find appropriate to disclose. I'm not very fond, probably because I'm from Switzerland, I'm not very fond of giving the rights to anyone to try to inquire in this in the information of private nature, or in the privacy of the management of the CAS. And I think that we need somehow to live with it. Again, I would encourage women to apply to be on the CAS list, and I'm quite convinced that they will have good chances to be on that list. Thank you for your attention.
Thank you, Jorge. One correction. I never said that it was easier for Swiss people to get on the list.
My bad.
But the rest I would stand by too. And I think in particular, you raise a very good point at the end. And I think the fundamental point also beyond this discussion about the structure and the reform of CAS, by insisting that this is a private institution. I think that's where I personally would depart from your interpretation, and I would side, obviously, with the European Court of Human Rights, who said that this is an institution whose jurisdiction is not based on private consent. It's a forced arbitration. And I think as soon as you accept that, and in my view now that it is recognized by the European Court of Human Rights, it's difficult to deny, you enter into a world that is much more public than private. And indeed, then it becomes legitimate to ask that certain public standards are applied, be it in terms of the publicity of the institution or the way arbitrators or judges are nominated. But I think this is the core debate that we are having. And in a way, also the core debate in terms of diversity. How much freedom should there be for the parties to nominate only people that are of a certain origin, or that are only male? And that's definitely the essence of our discussion. We had, I think,
if I may just add just one comment, if you, it's just very short. Lisa was saying that in the system of the CAS, you have to market yourself in order to be nominated. This is more or less true. I don't think that arbitrators are going to parties saying, well, if you nominate me, I'm going to stand by you and defend your point. I think that the arbitrators most often become or are nominated once they are on the list because they are visible and credible. And it's true that it goes, I mean, it requires sometimes to publish articles, it requires to go to the conferences, to be invited as a lecturer, etc. So it requires an effort. I'm not so sure. We nominate a lot of arbitrators in our firm, and it does not depend on the fact that these arbitrators contact us or buy us a lunch or whatever in order to be nominated in any case. There's just a specification. Thank you very much.
Marjolaine, do you want to?
Well, we are almost reaching the legal end of our of the webinar anyway. I thank Jorge. That's the benefit of having the meeting format, so we can receive expert participant input. There is an additional question. I'm not sure we have time to go into this, about the difference between the division and the anti-doping division, which goes more to the structure of the CAS. Generally speaking, maybe one question went into maybe the sharing of knowledge. I'm not sure I'm summarizing the question properly, but the idea was that maybe there should be academic partnerships and exchanges between experienced universities, and giving the opportunity also to for students in other countries to have access to knowledge locally and at reasonable cost. I don't know whether maybe Johann wants to comment on that one before we close.
Yeah, maybe we could couple it with some concluding thoughts as well, and then from both of you.
I didn't. I apologize. I was trying to keep an eye on the chat, but if so I missed that question. That Marjolaine was absolutely. I think that's a good idea in a sense too, and I guess this is similar to what we talked about earlier, how to make training information available in various ways. I think that's a very good idea. I think we're generally moving towards a democratization of higher education in many regards, and sharing of training and information. If I were to, I really appreciated Jorge's comment too. This is very insightful. This is about how this really works, and I think that's really good. I guess if I were to just make some kind of concluding remark, and I would echo a little bit what Antoine said. I think this is a dividing moment. I guess my view of this, both the question of why diversity matters, how we're going to go about this, it depends if we see this as traditional arbitration that is private and it's selected. I would, like Antoine, say that I don't believe this necessarily to be the case. The sport governing bodies as norm makers have been placed, maybe not exactly under the same level of scrutiny as public bodies, as state actors, but certainly many of the rules that today apply to sport governing bodies as rule makers and to global sports law are similar to those of to public entities. So if we look at, there's pressure both coming, like Antoine said, from the European Court of Human Rights, but also national courts in reviewing, ensuring that sport governing bodies comply with basic principles, such as the principle of legality and proportionality is an expression of this. It's something more than just private contracts. The European Union and the European Court of Justice certainly treat sport governing bodies in many regards similar to public entities. And from that lens, I think it's neither productive nor long-term viable to see CAS as a traditional private body of arbitration. And then the question is just how to take this step. What is the next step in order to be in compliance? Thank you very much.
I just have a couple of quick comments to make in conclusion. I also wanted to thank Jorge because I thought he raised some really interesting points, and I appreciate his contribution. And I think, you know, what he's sort of motivated me to say as my concluding remarks are that these issues of diversity and inclusion are captivating the world. It's not unique to the sports industry or unique to CAS appointments. These are very important issues that we're all facing in every kind of aspect of business and sort of world commerce. And so what I'd like to say is, whether you're a sports governing body or the CAS or an athlete representative, we're all in this together. we all have an industry that we love, the sports industry, and we all want it to be viewed with integrity and fairness and balance. And so I think we all have a role to play. And I just hope that going forward, whatever side you're on or wherever you sit, that you're more mindful about how we can move the ball forward and how we can embrace diversity and inclusion and how we can see more women and more minorities actually present on CAS panels and an integral part of, you know, the CAS world, and hopefully more of them as super arbitrators. And that's what I would like to say in conclusion. And thank you for everyone's participation today.
So thank you very much. I will leave then Antoine to close the session because I think he's the master of the Zoom. I just like to thank you really both of you for your participation. I'd like to thank the participants for sticking with us now after time. And I think just one concluding remark is that in the end, this diversity also goes over into the question of what we're now discussing about the diversity in representation in governments beyond the judiciary. This will be maybe, if it's not the next episode of Zoom In, one of the next episodes regarding governance reforms, in particular of WADA. So I'd just like to give this outlook into our future. And thanks to everyone. I'll leave Antoine to close.
Yes, I think I just can add to the thank you note of Marjolaine by thanking both Lisa and Johann and all of you for attending, for the questions, for the input. I think that's, what I really like with this webinars is indeed that we actually reach far beyond the usual participant in person to our events in The Hague. And that's also a little small contribution, and Johann insisted on it, but I think that we make to spreading knowledge across the world and making it relatively accessible. And I insist on relatively because there is still a big difference in access to even the internet, depending on where you are in the planet. And I hope it drives some of the participants towards a career in sports law and maybe a career as CAS arbitrators. I wish you that in any case. And I wish to see you back for the next edition, probably in November or early December. Thank you all, and have a good day wherever you are.
Thank you, everyone. Bye.
Thanks. Bye.